This is Advocate Lucinda, your empowerment lawyer. Every individual who goes to trial and has a jury, they have the right to have a jury of their peers. The jury must represent a cross-section of the community, demographically, racially, sexually, so on. Today I want to talk about a subject matter that's pretty sensitive, so hang in there with me, my friends, surrounding the selection of the jury. And the reason why I want to talk about that today is because pro se defendants don't know their right to have a jury of their peers. And part of that right is having a body of people that represent the cross-section, again, of the community. Now, what it does not mean is that just because the attorney during the voir dire select an all-white jury, that there is some discrimination, or there's an inference of some discrimination, or vice versa. If the jury selected is all black, or if the jury selected is all men, or that the jury selected is all women, that does not mean automatically that that was based on racism or discrimination. But here is the point. When eliminating or striking those jurors because they are black, or because they are white, or because they are female, or because they are male, that is discriminatory. And the failure of an attorney to give a race-based neutral explanation as to why he or she struck those jurors is an inference of discrimination. Until that attorney can make that explanation, then they got a problem. Okay, so let's get into it. Peremptory challenge. Let's talk about it. The Baston rule, or the Baston challenge, prevents lawyers from using peremptory challenges to exclude potential jurors during a trial solely based on race, ethnicity, gender, or religion. Peremptory challenges are the limited number of strikes lawyers, and that would include a pro se, use to remove prospective jurors without having to give a specific reason. So let's talk about this a little further. So, in addition to the peremptory strike that an attorney, including the pro se again, has the right to make, there's also the strike for cause. So let's look at the strike for cause. In the strike for cause, there is no limit to how many jurors an attorney can ask to remove for cause. To use these, the attorney must convince the judge that the prospective juror is inherently biased, cannot be impartial, or is otherwise unfit to serve on the case. That's the rationale for making the strike. Whereas with the peremptory strike, these are limited strikes where attorneys can remove a potential juror without having to give a reason. Now, the exact number of peremptory strikes an attorney has would depend on the jurisdiction, the type of case, and the number of defendants. And to help us address this, Baston, I love to look at case law. We're going to look at the United States Supreme Court, from which the Baston rule originated. It comes from the United States Supreme Court case Baston versus Kentucky, 476, United States 79, 1986 case, which held this type of peremptory challenge to be unconstitutional when used by criminal prosecutors. Now, think about that for a minute. I say that criminal trials are high stake. I'm not saying that civil trials are not, but in criminal trials, many times a person's freedom is endangered. And think about it, an attorney striking a juror without any rationale, that's a violation of that defendant's Fifth Amendment due process right. And given that the defendant has the right to be proven guilty beyond a reasonable doubt, peremptory strikes are antithetical to that. So let's get to the facts. Baston, a black man, was on trial charged with second-degree burglary and receipt of stolen goods. During the jury selection, the prosecutor used his peremptory challenges to strike the four black persons on the veneer, resulting in a jury composed of all whites. Baston was convicted on both of the charges against him. The question before the court was, did the prosecutor use of peremptory challenges to exclude the four blacks from the jury violate Baston's Sixth and 14th Amendment rights to a fair jury trial and his 14th Amendment right to equal protection of the law? The Supreme Court answered yes. Justice Lewis Powell wrote, in part, without identifying a neutral reason why the four blacks should have been excluded from the jury, the prosecutor's actions were in violation of the Constitution. He further opined that it undermines public confidence in the fairness of our system of justice. A peremptory challenge for strike can be constitutional when used by the defendant in a civil trial. A lot of people don't know that, but let's talk about it. And let's look at Edmondson versus Leeville Concrete Company, Inc., 500 U.S. 614, 1991 case. In this case, the Supreme Court remanded for a determination whether Edmondson had established a prima facie case of racial discrimination under the approach set forth in Baston. So let's look at the facts. Edmondson, a black man, sued for personal injury. Now remember, this is not a criminal case, this is a civil case. During voir dire, defendant Leeville used two of its three peremptory challenges to remove black persons from the prospective jury. Citing Baston versus Kentucky, Edmondson requested that the court require Lee to articulate a race-neutral explanation for the peremptory strikes. The court refused on the ground that Baston does not apply in civil cases, and as a result, the impaneled jury, which consisted of 11 white persons and one black, rendered a verdict unfavorable to Edmondson. And the question is, can a private litigant in a civil case exercise peremptory challenges without accountability for alleged racial classifications? Supreme Court said no. John Anthony Kennedy wrote, in part, a private litigant in a civil case may not use peremptory challenges to exclude jurors on account of race. I want to talk about four reasons that the court noted that I think is worth sharing with you here. Reason one for the court's ruling: Although the conduct of private parties lies beyond the Constitution's scope in most instances, Leesville's exercise of peremptory challenges was pursuant to a course of state action and is therefore subject to constitutional requirements under the analytical framework set forth in Lugar versus Edmondson Oil Company 457 US 922 457 US 939 through 942. Another reason, the court wrote, the claimed constitutional deprivation results from the exercise of a right or privilege having its source in state authority. And if you notice, I color code certain words. I'm saying here, this is significant. Since Leesville would not have been able to engage in the alleged discriminatory acts without 28 USC 1870, which authorizes the use of peremptory challenges in civil cases. Reason 3, Leesville must in all fairness be deemed a government actor in its use of peremptory challenges. Leesville has made extensive use of government procedures with the overt, significant assistance of the government, citing Tulsa Professional Collection Services, Inc. versus Pope 485, U.S. 478, and 485, U.S. 486. In that, peremptory challenges have no utility outside the jury trial system, which is created and governed by an elaborate set of statutory provisions and administered solely by government officials, including the trial judge himself, a state actor. Reason 4, the action in question involves the performance of a traditional governmental function. Terry versus Adams, 345 U.S. 461. Since the peremptory challenge is used in selecting the jury, an entity that is a quintessential governmental body having no attributes of a private actor. Reason 5, the injury allegedly caused by Leesville's use of peremptory challenges is aggravated in a unique way by the incidence of governmental authority. Shelby versus Kramer, 334 U.S. 1. Since the courtroom is a real expression of the government's constitutional authority, and racial exclusion within its confines compounds the racial insult inherent in judging a citizen by the color of his or her skin. Now, let's talk about how it works. So, during the voir dire, an attorney suspects the opposing side is using their peremptory strikes to eliminate jurors from a protected group. For example, again, removing all black, white, or female male jurors. They can raise a Baston challenge. This challenge, which is raised on the spot, triggers a 3-step process. The prima facie case. The objecting lawyer must show that the circumstances raise an inference of purposeful discrimination, for example, striking all minority jurors. The second, race neutral explanation. The burden then shifts to the attorney who made the strike to provide a non-discriminatory reason for removing the juror. Again, for example, the juror's body language, profession, or stated views. And the third is the judge's decision. The judge evaluates the explanation to decide whether it is genuine or just a pretext for unlawful discrimination. And again, this is done on the spot. The court is not wasting any time. And who it applies to? It applies to prosecutors and defense attorneys in criminal cases, and it has expanded to apply to civil trials. Well, I hope this has been helpful. Enjoyed putting this together. And as always, I'm Advocate Lucinda, and we will see you next time. Take care.